Hello there and welcome to Court This Week. I'm Dina Osha. In this special edition, we bring to you top stories of the legal proceedings from courts, from lower and subordinate courts to high courts and Supreme Court. We bring the selection of major legal proceedings which made headlines this week. In this next half an hour, we will also inform and update you on all important proceedings from the week. So let's start Courts This Week. The Rajasthan High Court on Friday ordered status quo to be maintained in the disqualification case against Sachin Pilot and 18 other dissident Congress MLAs. With this order, the court has barred Speaker C.P. Joshi from acting on July 14 disqualification notices. The order came after the High Court agreed to Pilot's request to make Centre a party to the case. The application was moved by Pilot on the ground that the 10th schedule's constitutional validity was under the challenge and therefore the Union of India was a necessary party. Pilot and 18 other dissidents MLAs had challenged a disqualification notice given by the Speaker in the High Court. The notice was given on the request of the Congress Chief Whip, who said Pilot and his supporters did not attend the party's CLP meetings.
In a relief to Sachin Pilot's-led group of Congress rebel MLAs, the Rajasthan High Court on Friday ordered status quo on the disqualification notices sent by the Speaker. The High Court also said that it was deferring the judgment on the petition filed by 19 rebel legislators till the Supreme Court decides on the questions of law. The status quo order essentially means that the Speaker will not be able to proceed further on the notices under 10th schedule of Constitution to disqualify the dissident MLAs, even if they do not submit their replies to it. The High Court on Friday also allowed the application filed by the petitioners to add Union of India as the respondent to the case. It was on 21st July that the division bench, comprising Chief Justice Indrajit Mohanty and Justice Prakash Gupta, had received the verdict on the petition filed by 19 Congress rebel MLAs led by Sachin Pilot against the disqualification notices sent by the Speaker. While doing so, the bench had requested the Speaker to extend the time for submitting replies to the notices, which was to expire at 5:30 p.m. on 21st July, till the delivery of the pronouncement of the judgment on 24th July. After making such a request, the bench said in the order, "We direct accordingly." Yesterday, the Supreme Court ordered that the judgment pronounced by High Court will be subject to the order passed by the Supreme Court in the petition filed by Speaker against the High Court direction to extend the time for reply. A bench headed by Justice Arun Mishra of Supreme Court observed that the matter required prolonged hearing due to the serious question relating to the democracy and adjourned the hearing to 27 July. It was on 14 July that the Speaker, Dr. C.P. Joshi, served the notices on the 19 dissident MLAs, including Pilot, amid their rebellion against Chief Minister Ashok Gehlot. They were initially given time till 1 p.m. July 17 to submit the replies. The basis of the notices was the complaint filed by Mahesh Joshi, the Congress party whip, who alleged that rebel MLAs had attracted disqualification under 10th schedule of the Constitution with their anti-party statement and refusal to attend the party meetings. Bureau Report.
Earlier this week, the Supreme Court has refused the request of the Rajasthan Speaker C.P. Joshi to stay the Rajasthan State High Court proceedings on Sachin Pilot and rebel MLA's petition against disqualification notice and posted a matter of detailed hearing for July 27th. The High Court has restrained him till July 24th from conducting disqualification proceedings against 19 dissident Congress MLAs.
The bench of Justices Arun Mishra, B.R. Gavai and Krishna Murari has refused to stay the order of the Rajasthan High Court or even transfer the matter from the High Court to itself. However, the Supreme Court has agreed to hear at length the plea filed by Rajasthan Speaker C.P. Joshi in the case concerning disqualification notices served on Sachin Pilot and 18 other MLAs. In the meantime, there will be no restraint on the proceeding before the Rajasthan High Court. However, the Supreme Court made it clear that the judgment of the High Court will be subject to the apex court verdict. The High Court will deliver its judgment in the matter on Friday, 24th July. Rajasthan Assembly Speaker C.P. Joshi has moved the Supreme Court against the order of the Rajasthan High Court that directed the Speaker to refrain from proceeding against Pilot and other rebel Congress MLAs till the High Court pronounces its order. Senior counsel Kapil Sibal, appearing for the Speaker, told the court that the challenge is mounted against the High Court's order as it passed an order with direction for the Speaker, which is beyond the High Court's jurisdiction. The court cannot direct the Speaker to extend time for disqualification proceeding. It is not within the jurisdiction of the High Court, Sibal. Referring to the Kyoto-Holohan case, Sibal argued that the paragraph 6 of the 10th schedule of the Constitution renders a finality clause to the decision of the Speaker. In light of this, the order of the Rajasthan High Court is not valid, Sibal argued. The final decision of the Speaker is subject to review, albeit on limited ground. But the proceeding prior to the final decision are not subject to the intervention of the court, Sibal further submitted. The bench inquired how the Kyoto-Holohan case became relevant in the instant case, considering that here the chief whip of the party is involved, not the Speaker. Sibal said the chief whip filed a disqualification petition against the rebel MLA based on which the Speaker issued show cause notices to them. The notice was for indulging in anti-party activities, which is demonstrated that Pilot and 18 other MLAs wish to part ways with the Indian National Congress. The court opined that the question involved in the plea needed a detailed hearing. Senior advocates Harish Salve and Mukul Rohtagi, representing Pilot's rebel faction, told the court that the Speaker himself had deferred the proceeding on his own violation twice. The Supreme Court eventually ordered that while there will be no restraint on the Rajasthan High Court in proceeding with the matter, its judgment will be subject to the outcome of the proceeding before the apex court. Rajasthan Speaker C.P. Joshi has contended in his plea that the High Court overstepped its jurisdiction by directing the Speaker to not proceed against Pilot faction. Further, this direction is in contravention of not only the 10th schedule but also of the principle laid down by the Supreme Court in the Kyoto-Holohan case. On 21st July, the Rajasthan High Court has reserved its verdict in the challenge to show cause notice issued by the Speaker. The High Court had directed that no coercive action is to be taken against Pilot and the MLA till 24th July, on which the date order will be pronounced. Bureau Report.
On the Bar Council of India's petition, which has asked to resume physical hearing in courts and financial assistance to lawyers amid COVID-19 situation, the Supreme Court acknowledged the dire situation and issued notice in the suo motu matter. The BCI plea urges the court for directions to government authorities to disburse loan of up to Rs 3 lakh to lawyers facing the brunt of the closure of courts.
The Supreme Court has issued notice in a plea filed by the Bar Council of India, drawing attention to the precarious financial position of lawyers due to the closure of courts amid the COVID-19 pandemic. The three-judge bench headed by Chief Justice of India, S.A. Bobde, also issued notice to the BCI and the central government in the suo motu plea taken up by the court on the issue. Notice has been also issued to the Registrar General of each High Court. The court addressed calls by lawyers' bodies for the reopening of courts during the COVID-19 pandemic. It stated, there is a constant demand to resume normal functioning of the courts. This demand is difficult as it jeopardizes the health of all those who attend court in congregation, including judges and lawyers. Medical advice is to not start resumption of court immediately. Nonetheless, it is not possible to ignore livelihood of lawyers. The lawyers' body stated that a significant section of the affected lawyers include first-generation lawyers. The petition reads, these advocates are solely dependent on the regular though meager income they earn from appearing in different courts and various tribunals as well as before the quasi-judicial authorities. This significant section of lawyers has no real saving to fall back on, and they are dependent on the regular functioning of the courts and tribunals for their livelihood. The bench has issued notice in the matters. The order reads, we therefore issue notice to all bar associations across India to showcase why a fund for relief for deserving and eligible advocates is not set up and invite donation from our own members or other legitimate sources. We issue notice to Bar Council of India and Centre in a suo motu case. Notice also to Registrar General of each High Court. According to the BCI, there are presently about 16 lakh advocates enrolled with the different state bar councils in the country. The plea has been filed by the Bar Council of India before the Supreme Court. Bureau Report.
An application has been filed before the Supreme Court seeking reconstitutions of the inquiry commission set up the court to probe into the genuineness of the encounter killing of the UP gang star Vikas Dubey. The Supreme Court has on Tuesday approved the constitution of an inquiry commission headed by Justice B.S. Chauhan and also comprising a former judge of Allahabad High Court, Justice Sashikant Agarwal, and former UP Director General of Police K.L. Gupta to look into the matter. The applicants have urged the top court to replace ex-DGP Gupta with some other ex-DGP from the state, imputing allegations of bias. He had annexed certain news reports where the former police officer has expressly told the media that the police version of the encounter should be accepted on face value. The petitioner submitted that in an internationally recognized common law principles, even as remote a likelihood of real bias can retaliate the entire proceedings, and has therefore urged the top court to reconstitute the committee to uphold the public confidence in the rule of law. Delhi High Court has directed the Indian Council of Medical Research to file an affidavit stating its stand on the requirements of a doctor's prescription for testing COVID-19. The said directions have been issued by the single bench of Justice Naveen Chawla in a plea challenging the mandatory requirements of a doctor's prescription to undergo a COVID-19 test filed by Utsav Sidhu, Reginald Valsalant and Rakesh Talukdar. The present read petition raises the grievances of the professionals who are required to travel to different states in course of their professional obligation. The petitioners have submitted that many states such as Himachal Pradesh require the individual to procure a COVID-19 negative certificate before allowing them. Therefore, it is the case of the petitioner that ICMR has not undertaken any steps towards ensuring that the mandatory requirements of a doctor's petition is done away with. It is pointed out that the petitioner that by an advisory dated July 1, the ICMR has strongly advised state to ensure that laboratories are free to carry out tests without the prior requirements of a doctor's certificate. In response to the contempt petition filed by Foundations for Media Professionals or FMP in Supreme Court, the Ministry of Home Affairs have filed a counter affidavit stating that the Special Committee to review the internet restrictions in Jammu and Kashmir has decided against restoring 4G internet in the region for now. The affidavit states that the Special Committee, in its meeting held on June 10th, decided that based on considerations and wide-ranging assessment of the prevalent situation in this sensitive region, no further relaxation on the internet services, including 4G services, could be carried out at present. A copy of the report of the committee will be placed before the court, states the affidavit. The MHA further informed the court that the committee will have its next review meeting after 2 months. Refuting the allegations of the Foundations for Media Professionals that the internet restrictions were extended in Jammu and Kashmir without constituting a special committee, the MHA said that a special committee stood constituted on the day of the judgment of Supreme Court on May 11 and not separate order was necessary for that. The 6-page affidavit states that the committee had its first meeting on May 15, 4 days after the SC verdict, and that all aspects of the matter were elaborately discussed, including the prevailing security situation in Jammu and Kashmir and the impact of the restriction placed on the 4G services in the region. The MHA further claimed that the suggestions made by the petitions before the SC were also discussed and debated. The contempt petitions was filed on June 9 by the FMP, alleging that a special committee to review the internet curbs in Jammu and Kashmir has not been constituted as per the SC directions. The Supreme Court has allowed the applications filed by the inquiry commissions in the plea seeking for investigation into the alleged encounter of 4 accused persons on December 6, 2019 in Hyderabad, praying for an extension of 6 months for submission of final report. A bench headed by CJI S.A. Bobde heard submissions of the advocate K. Parmeshwar appearing on behalf of the commissions and granted extension of 6 months.
Requesting for extending the duration of probe panel in the Hyderabad police encounter case, Advocate K. Parmeshwar submitted before the Supreme Court that the circumstances that have arisen due to COVID-19 pandemic and the subsequent lockdown have hindered the sitting of the Inquiry Commission, as the 3 members of the commission reside in different cities and the place of inquiry is in a wholly different city as well. The application submitted, however, mentioned that the Inquiry Commission's work was not completely halted by the pandemic, as collection of records and documents as well as statements of personnel acquainted with the incident went on despite the situation. On 12th December 2019, Supreme Court has directed for the constitution of an inquiry commission to investigate the circumstances which led to the alleged encounter of 4 accused persons in Hyderabad on 6 December 2019. The 4 accused persons had been in custody of the police in connection with the rape and murder of a young veterinary doctor. The commission is headed by former Supreme Court Judge Justice V.S. Sirpurkar and comprises of the former Judge of the Bombay High Court, Justice R.B. Sondur Baltoda, and former Director of Central Bureau of Investigation, D.R. Karthikeyan. A period of 6 months had been granted to the commission for completion of inquiry from the date of its first sitting. Accordingly, the Telangana High Court had given permission for accommodation of the Inquiry Commission, and the government of Telangana had issued sanction for the creation of 19 temporary posts for a period of 6 months to aid with the functioning of the commission. The term of reference of the Inquiry Commission were thereafter framed by the Supreme Court on 10th January 2020 and directed for an inquiry into the circumstances that led to the death of 4 persons and to ascertain as to whether any offence appeared to have been committed in the course. If yes, to fix the responsibility of erring officials. The first sitting of the Inquiry Commission was held on 3rd February and in public notice was published inviting persons acquainted with the matter of inquiry to come forward and furnish information to the Commission. The application states that in pursuance of the public notice, 1,365 affidavits were filed by various persons and almost all were in Telugu, therefore requiring translation into English. It is further submitted that relevant record from the NHR's investigation team, SITI investigation team have been collected as well as post-mortem reports. However, the application submits due to the declaration of the national lockdown in wake of the COVID-19 pandemic, work of the Inquiry Commission has been halted as they have been constrained to suspend sitting. The possibility of conducting online hearing and sitting were explored, but the same was abandoned by the Commission due to difficulties arising from security and confidentiality. In light of the above circumstances, the application prayed for an extension of 6 months for submission of final report from the date of Commission is able to resume investigation. It further prayed for the direction to the Government of Telangana to issue appropriate order to enable the continued functioning of the Inquiry Commission. Bureau Report.
In a significant judgment, the Madurai bench of Madras High Court has identified material inconsistencies in the police standing orders and set out specific directions to the department on when a person can be considered a history sheeter. The Madras High Court has delivered a major judgment on history sheeters. While disposing of a batch of 30 writ petitions seeking removal of the petitioner's name from the history sheets for various reasons, the single judge bench of Justice N. Shishasai observed the need for effective policing through history sheeting and the arbitrary and malified exercise of police power in history sheeting on individual are conceptually different. This court, being adorned with the duty of being a constitutional sentinel, has to balance between the right of an individual to his fundamental rights as against the interests of the society in maintaining law and order through effective preventing policing. It has therefore issued 10 directives to be followed by the police personnel in the matter of history sheeting until statutory alternatives for the same are notified. In terms of the PSO 747, history sheets shall be opened automatically at the time of conviction for persons convicted under certain specified offences and shall be retained for 2 years after release from jail. Findings these provisions to be least troublesome, the bench observed.
In terms of the PSO 747, a convict alone will be history sheeted and will remain a history sheeter during the term of his sentence plus 2 years. A citizen's right is protected here since the sine qua non for history sheeting is the judgment of a court. This is akin to the National Registry of Sexual Offenders brought about under the Criminal Law Amendment Act 2018. It has a relative base with a judicial verdict as its backing. The two areas where the power of history sheets is arbitrarily exercised, the court observed, are while exercising power under PSO 749 and while retaining a history sheeter under PSO 748. 2. Under PSO 7491, a history sheet can be opened for suspects, but it presumes every person who is convicted even once for any offense under the IPC as a suspect. Bureau Report.
The fundamental right to religion under Article 25 of the Constitution of India does not extend to offering prayers at each and every place and protecting a place of worship illegally built on public places, held the High Court of Karnataka. The court added that right to construct an authorized temple cannot be said to be an essential religious practice that can be protected under Article 25 of the Constitution. A division bench comprising Chief Justice Abhay S. Oka and Justice M. Naga Prasanna held the fundamental right under Article 25 of the Constitution of India does not extend to offering worship or prayers at each and every place. Surely, the fundamental rights under Article 25 of the Constitution of India cannot be invoked for protecting an illegal structure of a temple which is on a footpath. The right to construct unauthorized temples, and that also on a footpath, cannot be said to be an essential part of any religion or religious practice, which can be protected under Article 25 of the Constitution of India. A Residents' Welfare Association, which intervened in the writ petition seeking to protect the temple, faced the wrath of the court. It was argued by their counsel that the temple were established in 1854. Initially, the construction was not a road or a footpath, but as the road was widened, it happened to be on the footpath. Accordingly, the court imposed a cost of Rs 25,000 on the members of the Residents' Welfare Association. The cost was directed to be deposited, the amount with Chief Minister's COVID-19 Relief Fund with 6 weeks. Well, that's all in court this week. Thank you so much for tuning in. Keep watching APN and stay safe.